All right, ladies, gentlemen, boys, girls, papas, mamas, welcome to my YouTube channel. Of course, we are still on our series on criminal litigation, and today we'll be looking at criminal jurisdiction. Now, I made out some, questionnaires or questions that would help me teach this particular topic. Now, we are looking at criminal jurisdiction. This is the next topic that we would have to look at after the other ones that we've just looked at. Now, the first question on this particular questionnaire is, what is jurisdiction? Of course, you know, if you are in the law school or if you are going into the law school, your undergraduate days, you must have looked at what jurisdiction is. And you must have known that jurisdiction is the powers of the court to hear a matter. So when the court does not have powers to hear a matter, then you say that the court does not have jurisdiction. Yeah? So now, what do we consider in order to know if a court has jurisdiction to hear a matter? Now, that can be seen in the case of Masterclass against Nkemdelem. In fact, you see this case, Masterclass against Nkemdelem, it is a locus classicus. When I mean it is a locus classicus, when you talk about jurisdiction and you have not talked about Masterclass against Nkemdelem, I don't think you have started talking about jurisdiction. Because Masterclass against Nkemdelem is a case that you would see if you are talking about jurisdiction. So, of course, you have things that the court will consider. Number one, whether the court was constituted as to the number of judges that should be there and the qualifications, of course, of the judges. So what do I mean? In the Supreme Court, you are supposed to have 5 justices, yeah? Of course, apart from when the Supreme Court is sitting in original jurisdiction and apart from when it is sitting in appellate jurisdiction as regards matters in section 233 sub 2 paragraph C and D, or B and C, paragraph B and C or something. So you see that in section 234 of the Constitution. So read section 234 of the Constitution and you would see what I'm talking about. So, of course, we are still looking at what the court will consider. So we are considering, so I was giving an example. So the Supreme Court should be 5 justices when hearing a matter, apart from the times there should be 7 justices. So if they are supposed to be 5 justices and they are now 4 justices, it becomes a problem. It means that the courts would not have jurisdiction to hear that matter until they are 5 justices. Now, what if one of the justices do not have the qualification to be a justice? Now, what is the qualification of being a justice of the Supreme Court? I'm using Supreme Court as an example. Number one is that you must have practiced law for at least 15 years. So if one of the justices is just like me now, that I've not reached 15 years, I've not even reached 10 years at the bar, and you now see me as a Supreme Court justice in your case, you will say that the Supreme Court in that regard does not have the jurisdiction to hear the matter. Good. So, apart from that, you also have another thing the court will consider according to Masterclass against Nkemdelem is the due process of law. Was this matter brought through the due process of law? Was this matter brought how the law says we should bring this matter? So what do I mean? If a matter is supposed to be brought by charge in the criminal setting and you bring it by information, do you think that it will vest the court with the jurisdiction to hear the matter? Or maybe it is supposed to be by information and you bring it by first information report. Do you think it would vest the court with the jurisdiction? So the court also considers the due process of bringing your matter to court. Then the court will also consider whether the court has substantive jurisdiction. Of course, substantive jurisdiction is very, very important. When the law have said that, okay, this is the kind of matters that this particular court would treat. Then again, we look at condition precedent. Condition precedent. So if there is something that you are supposed to do that you did not do, it will strip the court of jurisdiction. So condition precedent and all that. So go and read the case of Masterclass against Nkemdelem. It was decided in 1962. It was reported in 1962. I don't know when it was decided. Maybe it was decided before then, but in 1962 it was reported. Now, we look at the sources of jurisdiction. Where do courts get their jurisdiction from? Of course, courts get their jurisdiction from the Constitution. When you look at the Constitution, the relevant sections of the Constitution, you will see that the Constitution listed out most of the jurisdictions of the court. You understand? So you look at if you look at section 230 that provides for the Supreme Court, you go down to like section 233, section 232, you see the jurisdiction, original and appellate jurisdiction. So when you look at this, the Constitution, you see the jurisdiction of courts. When you also look at statutes creating courts, laws that are creating courts, then the jurisdiction of courts are there. So the sources of jurisdiction is by the Constitution and by the laws or acts that are creating these courts. So what happens when an offense is committed partly in a state and completed in another? So let us say in Lagos State, somebody started an offense, started beating somebody here in maybe let's say Lagos State, and moved the person with his vehicle to like what is close to Lagos, Ogun State, and was beating him in Ogun State too. And of course, he died. Where would be the appropriate court that would have jurisdiction to hear the matter? Of course, the court in Lagos State has jurisdiction to hear the matter. The court also in Ondo State has jurisdiction to hear the matter. So if the offense that was committed partly here and partly there, the courts here and there would have the jurisdiction to hear this matter. So the reason I am sounding this is because it is possible that your exam might come like this. They did this one here in this state and they went to this state. Comment on the jurisdiction of the court. Maybe they now say now it was not brought to a state. Then you have to say that yes, the courts in either of the states have the jurisdiction to hear the matter. Now, classification of criminal jurisdiction. Of course, we have courts with general criminal jurisdiction and we have courts with special criminal jurisdiction. Of course, with the name, you would know that courts with general criminal jurisdiction are courts that any kind of, mostly any kind of criminal matter can come to them. However, courts with special criminal jurisdiction is just for specific offenses, which of course would have been provided for by the law. So we look at, we'll first start with the courts with general criminal jurisdiction. When we come to the south, we see the customary court and we see the area courts in the north. So the customary court, of course, it's just the most important things that I'll have to give you. So when next you want to read about it, you can read about it and see some other information that probably you would need. Now, customary courts, of course, do not have the powers to give punishment exceeding 14 days imprisonment or 5,000 naira fine. So it is very important you know that, because you might see a particular question that says that the customary court has given 1 year imprisonment. They will not say comment on the validity or otherwise of the customary court's decision or punishment. Then you would now say no, it is invalid, because you now say the law. By that time you must have read and known the law. You now say they don't have the jurisdiction to give punishment above 14 days. Yes, so that's customary. Customary court is one of the courts with general criminal jurisdiction. Again, we have area court, of course. Area court is for the north. Now we have the magistrate court. The magistrate court, they have general criminal jurisdiction. But of course, we are looking at Magistrate Court of Lagos State. You look at section 29 of Magistrate Court of Lagos State to see the offenses or the kinds of offenses that they have jurisdiction over. Of course, the magistrate courts do not have jurisdiction over capital offenses punishable by death. And remember, they don't also have jurisdiction to give you punishment above 14 years imprisonment. So if you've committed an offense that has over 14 years of imprisonment, of course, you see that they do not have jurisdiction to give above 14 years imprisonment. So where they now give above 14 years imprisonment, you can appeal. But your appeal will not be for the decision to be quashed, for the conviction to be quashed. Your appeal would be that the excess of 14 years be removed, and that appellate court would now give you that 14 years. So you're appealing not because you want the conviction to be quashed, especially if you're appealing on the ground that the magistrate court, they do not have the power to give more than 14 years imprisonment. What the appellate court will do is to cut down the appropriate to cut down the imprisonment, the terms of imprisonment or the years of imprisonment to the appropriate imprisonment years or terms that the magistrate courts have powers to give. Okay, so that is for magistrate court. Now we have the high court. The high court, of course, before they usually call the high court courts with unlimited jurisdiction. So the High Court have, of course, powers, not unlimited though, but then they have more powers for more criminal jurisdictions, for more criminal offenses. Now, the High Court, unlike the Magistrate Court, they do not have limits to their punishment. So the High Court can give as high as a death sentence. It can give as high as life imprisonment. So they do not have limits to, the punishment. However, there are some offenses that some acts or some laws have given the Federal High Court exclusive jurisdiction, just like you see the NDLEA Act. The NDLEA Act has given the Federal High Court exclusive jurisdiction to hear drug-related offenses. So, in that regard, the Federal High Court has jurisdiction exclusively to hear that matter. So, if you bring it to the High Court of the state, even though it is said or it is agreed, it is believed that the High Court of the state has unlimited jurisdiction, but when the law has exclusively given the Federal High Court authority to hear a particular criminal matter, then you cannot say that the High Court can hear that criminal matter by virtue of the fact that it is a court with unlimited jurisdiction. I don't know if you understand what I'm saying. Okay, that is for High Court. Now, of course, when you now go to Court of Appeal and Supreme Court, they are courts with general criminal jurisdiction, but on appellate basis. Now, when we continue, that is for courts with general criminal jurisdiction. Now, when we look at courts with special criminal jurisdiction, we look at juvenile courts. Now, juvenile courts, of course, from the name juvenile, you are looking at a court that deals with children and young persons. Of course, it was created from the Children and Young Persons Act or Children and Young Persons Law. Yeah? So, when you talk about juvenile court, you are talking about an age bracket. Now, it is important to note that by the Criminal Code and by the Children and Young People's Act, people that are, or children or infants that are from 1 year to 7 years, they do not have the capacity to commit any offense. And so, no court will apply to them. So, a child from 7 years to 12-year-old will only be liable to an offense if at the time he is committing the offense, he knew what he was doing. And so if you cannot prove that that child knew what he was doing as at the time that he was committing the offense, then they do not have criminal liability. Now, from 12 to 14, of course, have criminal liability and can be tried in the juvenile court. Now, from 14 to 18, or from 14 to 17, or below 18, are the people we refer to as young persons. You get? And they also have criminal responsibility, liability. So, the relevant age of conviction is not the age the person was as at the time of conviction, but the age he was as at the time he committed the offense. So, the relevant age we are talking about is the age of commission of the offense. So somebody will not commit an offense when he was maybe 17 years, and as at the time the particular matter was going on in court, years has passed, and by 21 years he's about to be sentenced. And you're not telling me that because he's 21 years now as an adult, he should be sentenced just like an adult. No, the relevant age that we are looking at is the age he was when he committed the offense, and not the age of conviction. Now, how do we determine age? What is the determination of age? You determine age by, number one, direct evidence, when you present the birth certificate in court. Number two, by oral testimony of the parents. The parents must come and give oral testimony. Or number three, by medical analysis and medical examination by an expert. So these are the three ways you can determine the age of a child. So somebody will not be 21 years. See as I am now with all this my mustache, and I will not tell you that I am 17 years just because I want to run away from criminal responsibility or criminal liability. Of course, when you want to prove my age, you have to bring my birth certificate. And when you see that my birth certificate started from 19, then you will now know that this person is not a young person. Okay, that is determination of age. Now, that is for juvenile courts. Now, there is an exception to juvenile court. Now, every child can be tried or should be tried by the juvenile court, except when the child is accused of committing a capital offense or when the child is accused of committing an offense with another adult or with adults. So that is when, of course, the High Court can have jurisdiction to try the child. So the child is being accused of committing a capital offense, or the child is being accused of committing an offense with an adult, in connivance with an adult. Now, can a child be in prison? A child should not be in prison. Of course, children are detained in the pleasure or to the pleasure of the governor. However, even if you imprison a child, he must not mix with other prisoners, other adult prisoners. So that is it. We look at court-martial. You have types of court-martial. We have the general court-martial. We have the special court-martial. Now, there is no, when you are talking about the composition, there is no much difference. The same parties, not like the same parties, the same people that are here, just that the number of members are different. So in a court in the general court-martial, we have the president of the court-martial. We have not less than 4 members. Yeah, we have a liaison officer, we have a waiting member, and we have a judge advocate. Now, in the court-martial, the special court-martial, we have the president, we have not less than 2 members, then we have the judge advocate, the liaison officer, and a waiting member. So the difference between the general and the special court-martial is that in general court-martial, you have not less than 4 members, while in the special court-martial, you have not less than 2 members. So in order for you to know, but other ones are the same. Other members are the same. Who convenes the court-martial? Now, the person that convenes the special court-martial is a leader of the battalion. I don't know what they call it, maybe a general of the battalion, a leader of the battalion, a commander of the battalion, of course, or anybody he delegates the power to do that. However, the general court-martial is convened by the president of the Federal Republic of Nigeria, or the chief of defense staff, or a brigadier general in charge of whatever brigadier general is in charge of. Of course, the decision of the court-martial is based on votes. Yeah? And when there is a quality of votes, listen attentively. When there is a quality of votes as to findings, the accused or the defendant is discharged. However, when there is a quality of votes as to sentencing, the president would have a second vote or a final say. Who and who signs the decision of a court-martial? The decision of a court-martial is signed by the president of the court-martial and the judge advocate. Failure for these two people to sign this decision renders the decision void and nullity. In fact, the decision is as good as it did not happen. Now, appeal against the court-martial goes to the Court of Appeal, and it must be, entered within 40 days of the promulgation of the decision of the court-martial. Of course, if it is death sentence, it should be within 10 days. Now, the Code of Conduct Tribunal is a court with special jurisdiction. Of course, that one that tries public officers and all that. We have the Federal High Court. Of course, the Federal High Court is a court with special jurisdiction. They're asking, how can you say that the High Court is a court with general criminal jurisdiction, and you say that the Federal High Court is a court with special criminal jurisdiction? It's very simple. The Federal High Court has, of course, exclusive jurisdiction to hear some matters. But the question is this. The matters where the Federal High Court has exclusive jurisdiction to hear, do they extend to criminal proceedings? Do they extend to criminal matters? So let us say the Federal High Court has exclusive jurisdiction, of course, according to Section 251, to hear matters on, let's say, admiralty. Is it now a must that anytime an offense emanates from admiralty, that it must be the Federal High Court that has the jurisdiction? The answer is no. The Federal High Court do not have criminal jurisdiction over those Section 251, over those items in Section 251 of the Constitution. It is only civil jurisdiction they have over the Section 251 of the Constitution, because the law did not expressly state that criminal proceedings or criminal jurisdiction should be extended to as regards those items under Section 251 of the Constitution. So that is Federal High Court. However, like I said, there are some laws or some acts that have given the Federal High Court exclusive jurisdiction to hear matters. And I gave an example of the NDLEA Act. Also, an example is also given of the Terrorism Act. So we now have the National Industrial Court. Of course, you know what the National Industrial Court is, dealing with workplace and all that. So any offense that is coming up under the NIC, under the matters where the NIC has already civil exclusive jurisdiction, just like the Federal High Court, they do not have criminal exclusive jurisdiction to hear those matters. So those matters that they have exclusive civil jurisdiction to hear, I mean section 254A of the Constitution, they do not have exclusive criminal jurisdiction. It doesn't mean that criminal jurisdiction cannot be instituted there. You can institute criminal jurisdiction there in respect of those matters, but they do not have exclusive jurisdiction to hear the criminal part of those ones. What they have is exclusive civil jurisdiction to hear what section 254A, of course, B and C listed. So, at most, the High Court also has concurrent jurisdiction to hear those matters falling under the purview of the jurisdiction of the NIC when it is in criminal proceeding, or when it is in criminal regard. So, in essence, the NIC has, of course, powers that are listed for them exclusively civil. In the civil aspect, they are exclusive. If you go and carry a civil matter that your boss sacked you, and you come to the High Court, the High Court will tell you they don't have jurisdiction. You have to go to the NIC because they have the exclusive jurisdiction to hear the matter. However, if you come to the High Court for an offense that happened in the workplace, which, of course, workplace, trade union, and all that is what the NIC has jurisdiction. The High Court cannot tell you that they don't have jurisdiction because this is a workplace something and it should be in the NIC. No, because they have concurrent jurisdiction with the NIC. So the NIC can also hear it, but other courts like the High Court can also hear the matter. So is the Court of Appeal the final bus stop for appeals from the NIC? Of course, you know that in civil appeals, the Court of Appeal is the final bus stop. What do I mean? When you are appealing from the NIC in civil appeals, it is the Court of Appeal that it has the final say. Of course, except fundamental rights matters and except criminal proceedings. So, this means that in criminal proceedings instituted in the NIC, it will reach the Court of Appeal and it will still cross the Court of Appeal to the Supreme Court. However, in civil matters, the Court of Appeal has the final say, apart from fundamental rights matters. So you should get that into your head. So Coroner's Court is also a court of special criminal jurisdiction, but Coroner's Court is not a court of trial, but a court of inquest. So when you are trying to make an inquiry over or on the death or the sudden death of a particular person or the circumstances of death, then you go to a Coroner's Court. Now, can the AG enter a nulli prosecute in a Coroner's Court? No, the AG do not have the powers to enter a nulli prosecute in a Coroner's Court. Now we have the International Criminal Court that was established by the Rome Statutes, which came into force in 2002. Yes, and the ICC, the International Criminal Court, deals with matters. The jurisdiction is on crimes against humanities, crimes of genocide, crimes of aggression, and war crimes. So that is the ICC. The ICC is an international criminal court. Of course, they do not only look at states. Yeah, they don't even look at states. They look at people, members of the member states. So citizens of member states that are signatory to the ICC. Yeah, they look at they get them and they prosecute them. This is a criminal court and it's a court of special jurisdiction. Now let us look at holding charge and remand orders. Now, before, even till now they do it. When we were in the law clinic, when we went for prison visit, we saw that this particular holding charge is still in practice. Now, what is holding charge? You know, in section 35, subsection 4, yeah, and subsection 5, they were telling us that reasonable time, when a police arrests you, that they are supposed to keep you in cell or detention for a reasonable time, and they are supposed to charge you to court within that reasonable time. And they went ahead in the Constitution to explain to us what a reasonable time is. And in the Constitution, they said that the reasonable time is 24 hours, when a court is within 40 kilometers and 48 hours when the court is not within 40 kilometers. Now, in order to run away from liability, the police people, those years, will go and arraign you in court and say you have brought you to court within reasonable time. But when they arraign you in court, they will now tell the court that, yes, please take this person into the prison while we investigate, while we await the advice of the DPP, while we bring together our investigation and we give the DPP, and the DPP will now give us advice as to whether to prosecute or not. So that is holding charge. So it was leaning on injustice, because when somebody is brought to court, arraigned in court, and they remand the person in prison custody, and any time that they want to come back, they did not have any time limit. So we now saw that they were using it to put people into prison and to leave people there. Even now that it was abolished, we still go to prison visit and we see that some people were still in the prison through this holding charge, that they'll bring them to court, they'll say they will take a plea and they will do the remand this thing, and they will keep them there without checking up on them, without any time frame as to when they will come out. So it became a problem, and so it was supposed to be abolished, and it was abolished. Now it was now replaced with what we call the remand proceedings or the remand orders. Now what is the remand order? Now the remand order is just like holding charge, but now they now put a time frame. In Abuja, it is 14 days. If there is need for him to still be in the prison after that 14 days, he must have to come and show cause. The prosecution will have to come and show good cause to the court. And the court will now say, okay, based on this good cause that you have shown, if I am satisfied, if the court is satisfied, you now extend it for another 14 days. So there is a particular time you will extend it for, I think another second 14 days, then the person will be released unconditionally. Meaning you have not finished your investigation. So why is this person still in prison? Go and finish your investigation. The person will have to be released. Go and finish. When you are done with the investigation, you want to go ahead with the case, then bring the person again so that we will now start the case. Not go and put somebody inside prison and try to resurrect holding charge when you are using remand proceeding. So remand proceeding is now here. Remand proceeding puts a particular time frame in order for you to remand somebody in prison custody. Not leaving the person like that without any time frame and saying that you are waiting for DPP's advice. Now, we have come to the end of this criminal jurisdiction on criminal litigation. Anyone you don't understand, just ask me in the comment section and I'll be very, very happy and glad to answer you. Take care of yourself and I'll see you on the next one.